Representative Fett, Representative Gustav, Representative Nordman, Representative Olson,
Excused.
Representative Ramirez, Representative Shipley, Representative Srinivas, Representative Stone, Representative Thompson M, Representative C. Thompson, Representative Watkins, Representative Wessel Crushell, Representative Wheeler, Representative Wickendall, Representative Williams, Representative Wills.
The minutes of the previous meeting were distributed electronically. If there were no objections, I would move approval of those minutes. So ordered. Today we have 19 bills to consider. At this time, the chair recognizes Representative Wheeler for opening remarks on House Study Bill 668.
Thank you, Mr. Chair. House Study Bill 668 promotes merit-based colorblind policies in state employment, education, and licensing by eliminating race or gender-based preferences and requirements. It reduces unnecessary bureaucracy, ends mandated affirmative action plans, reports and dedicated administrators. It maintains core anti-discrimination protections. Individuals cannot be denied opportunities based on protected characteristics. The bill targets only affirmative remedies and preferences. Mr. Chair, there is an amendment.
There's an amendment. Chair recognizes Representative Wheeler for opening remarks on Amendment 2757.
Thank you, Mr. Chair. This amendment simply removes affirmative action in other areas of the code and changes the requirement that the state reports efforts to promote minority and women-owned businesses and changes that to Iowa-based businesses. Those are my opening remarks.
Is there discussion on the amendment? Chair recognizes Representative Srinivas.
Thank you, Mr. Chair. We heard from several members of the public, including people who are former law enforcement, that they were concerned about removing racial and bias training, which has become a core part of what they do in the field. And this amendment does that. So I urge you to listen to our professionals and vote this down.
Thank you. Is there any further discussion on the amendment? Seeing none, Representative Wheeler moves Amendment 2757. All those in favor signify by saying aye. All those opposed say no. Ayes appear to have it. The ayes you have it. The amendment is adopted. We are back on House Study Bill 668 as amended. Is there further discussion? Chair recognizes Representative Srinivas.
Thank you, Mr. Chair. I have received hundreds of emails. There were public comments, and we even had a very full subcommittee on this bill. And of those hundreds of voices that came, not one single Iowan said that this was a good bill. One of the biggest issues that came up over and over again throughout the discussion was what is going to be the impact on our workforce issues here in Iowa. It has been clear for years, every sector in Iowa talks about how they are having trouble recruiting and retaining workers. And that is something that we as a legislature on both sides of the aisle have worked together to try to figure out what can we do. And it's been a discussion that is still ongoing. This bill is not the answer to that. If anything, it actually worsens the problem. There are several sections in this bill that specifically look at licensing of different professionals, everything from the medical field, so physicians, to engineering, to architecture, to real estate. And it specifically removes the prohibition of discriminating for licensing based on citizenship status. Let's talk about what that looks like in reality. When we look at Iowa's healthcare workforce, for instance, that's an area that I'm very intimately familiar. One of the biggest ways that we recruit people to work in rural Iowa and small town Iowa when it comes to being a physician is through a process called the J-1 visa. It means after they have finished their residency training, when they are applying for jobs, they are looking for a place that will welcome them in a place of high need, low resources, which is many parts of rural Iowa. That J-1 visa helps us to attract physicians where no one else will go. But now, if they're going to be given the choice between going to Nebraska in a rural area or Iowa in a rural area, and in Nebraska, they are guaranteed they will not be discriminated against because of their visa status. But here in Iowa, they might be denied a license because of that, because we passed this bill that will legalize discrimination based on citizenship status. Why would they choose to come here? 1 in 4 physicians in Iowa came here as an international medical graduate. That means that their citizenship status, not being discriminated against, was key in drawing them here to serve our communities. 1 in 5 nurses were immigrants. We're looking at pharmacists, at mental health therapists, at physical therapists, occupational therapists, caseworkers, social workers, people that are integral to making our hospitals, our clinics run, and keeping our communities healthy. We are already in a massive shortage when it comes to our healthcare workforce. It's why we're seeing months wait time when it comes to having to see a specialist in many cases. And a lot of these diagnoses can't wait that long. We are one of the highest rates of cancer in the country. And when it comes to having to see a cancer specialist, if you have to wait months, that can be the difference between life and death. This bill will worsen that wait time. And it's not just looking at the healthcare workforce. In here, we also talk about engineers. Well, Iowa is number one in something. We're actually number one when it comes to structural deficits of our infrastructure and bridges in the country. One of the reasons for that is, once again, we don't have enough of a workforce. Why are we trying to now discriminate and discourage engineers from coming here who could help to fix that problem? Even looking at another industry, large animal veterinarians. We talk about this over and over again. We need more large animal vets. We even have bills this year that are looking at trying to incentivize how we can recruit and retain veterinarians in our rural communities. Well, both of my parents are large animal vets. The reason they chose to live in Iowa, make Iowa home for all of us, is because they knew they could come here, that we could get a great education, and that they wouldn't be discriminated against and they could flourish in their career. They were able to get licensed even though they were here on a green card. Not a full citizen yet, but permanent residents here legally, and they weren't risking being discriminated against. Them settling here made them raise a person who is now a doctor in these communities. They also raised an engineer. Two areas that we badly have deficits in. By denying people coming here who are filling these vital gaps, we are denying Iowans the quality of life that they deserve. Why are we doing a bill that will only vastly cause that to be more devastated? Why are we voting against our own best interests? With that, I ask you to reject this bill today. Thank you.
Thank you. Is there any further discussion? Seeing none, the chair recognizes Representative Wheeler for closing remarks on House Study Bill 668 as amended.
Thank you, Mr. Chair. This bill does not create new requirements for U.S. citizenship, nor bar non-citizens who are legally here from working or obtaining licenses. Does not override federal immigration or work authorization laws. For example, those with J1s would still be eligible to work just the same. In short, Mr. Chair, the best way to stop discriminating based on race is to stop discriminating based on race. That's from Chief Justice John Roberts. I move the bill as amended.
Representative Wheeler moves House Study Bill 668 as amended. Clerk will call the roll.
Representative Holt,
Aye.
Representative Lawler, Representative Wilburn,
No.
Representative Bagneski, Representative Dunwell, Representative Fett, Representative Gustoff, Representative Nordman, Representative Ramirez, Representative Shipley, Representative Srinivas, Representative Stone, Representative M. Thompson, Representative C. Thompson, Representative Watkins, Representative Wessel Chrisell, Representative Wheeler,
Aye.
Representative Wickendall, Representative Williams, Representative Wills. 14 yay. 6 nay.
6, did you say?
6.
With a vote of 14-6, House Study Bill 668 as amended will move to the floor as a committee bill. The chair recognizes Representative Wheeler for opening remarks on House File 430.
Thank you, Mr. Chair. House File 430 prohibits the enforcement or implementation of so-called red flag gun laws, also known as extreme risk protection orders. Red flag gun laws in other states generally allow law enforcement or family members to petition a court to temporarily seize firearms from individuals deemed an imminent danger to themselves or others. For example, due to threats, mental health crisis, or warning signs of violence, often with an ex parte, initially one-sided order, followed by a hearing. This bill defines what a red flag law is: law, order, or measure that directs the seizure or confiscation of a firearm from law-abiding citizen without the adjudication of a contested court case, i.e. without due process. Mr. Chair, there is an amendment.
There's an amendment. The chair recognizes Representative Wheeler for opening remarks on Amendment 2543.
Thank you, Mr. Chair. This amendment simply clarifies that a person in lawful custody or one released after paying bail If they've never been charged with a violent felony, they can still have their weapons seized. Those are my opening remarks.
Is there discussion on the amendment? Chair recognizes Representative Wilburn.
Thanks, Mr. Chair. I recommend a no. I'm not quite sure that, that this may actually expand, but I need some more information, so I recommend a no.
Any further discussion? Seeing none, Representative Wheeler moves Amendment 2543. All those in favor signify by saying aye. All those opposed say no. The ayes appear to have it. The ayes do have it. The amendment is adopted. We're now back on House File 430 as amended. Is there discussion? Chair recognizes Representative Wilburn.
Again, opposed to this. There have been some studies that show red flag laws, a temporary removal of a weapon for someone that might be a risk for themselves and their families, of which there have been in the state of Iowa, and I've actually known a few families where this has been an issue, and a parent killed their family and then themselves, and this type of order may have been successful. There have been some empirical studies that show one life is saved for every 17 to 23 orders issued. And I think that would be worth it to keep that open for Iowans to keep communities safe with that, as with mass shootings. So recommend a no.
Thank you. Is there any further discussion? Seeing none, Representative Wheeler, you're recognized for closing remarks on House File 430 as amended.
Thank you, Mr. Chair. This was a lively subcommittee. Nobody showed up. So myself, Representative Wilburn, had to kind of figure out some of this on our own. I just simply want to touch on Representative Wilburn on the amendment. I actually think it does a little bit of the opposite of what you say. I think it tightens down a little bit. And I'm happy to talk to you afterwards if you'd like to about that too. With that, Mr. Chair, I move the bill.
Representative Wheeler moves House File 430 as amended. Clerk will call the roll.
Representative Holt,
Aye.
Representative Lawler, Representative Wilburn,
No.
Representative Bagneski, Representative Dunwell, Representative Fett, Representative Gustav, Representative Nordman, Representative Ramirez, Representative Shipley, Representative Srinivas, Representative Stone, Representative M. Thompson, Representative C. Thompson, Representative Watkins, Representative Wessel Chrisell, Representative Wheeler,
Aye.
Representative Wickendall, Representative Williams, Representative Wills. 14-6.
With a vote of 14-6, House File 430 as amended will move to the floor as a committee bill. Chair recognizes Representative Wills for opening remarks on House File 2145.
Thank you, Mr. Chair. Good afternoon, ladies and gentlemen. This bill simply removes the ability of the governor to close down churches and houses of worship during an emergency.
Is there discussion on House File 2145? Chair recognizes Representative Russell Chrisell.
Thank you, Mr. Chair. I believe in the event of an emergency that we need to make sure we have all the tools available to protect Iowans and keep them safe. I don't love the idea of closing down places of worship, and certainly that needs to be a last resort. But in the case of an emergency, I do believe that we need that flexibility in the state. So I am a no on this bill.
Thank you.
Is there any further discussion? Seeing none, Chair recognizes Representative Wills for closing remarks on House File 2145.
Thank you, Mr. Chair. Religion is a protected right under the Bill of Rights of the United States, both and as well as the state of Iowa. Churches have the ability to make the decision on whether they should close down or not. Individuals have the ability to decide whether they should go to church or not. This is a personal responsibility and also a protected right. Move the bill.
Representative Wills moves House File 2145. The clerk will call the roll.
Representative Holt,
Aye.
Representative Lawler, Representative Wilburn,
No.
Representative Bagneski, Representative Dunwell, Representative Fett, Representative Gustav, Representative Nordman, Representative Ramirez, Representative Shipley, Representative Srinivas, Representative Stone, Representative M. Thompson, Representative C. Thompson, Representative Watkins, Representative Wessel Chrisell, Representative Wheeler, Representative Wickendall, Representative Williams, Representative Wales. 16-4.
With a vote of 16-4, House File 2145 will move to the floor as a committee bill. The chair recognizes Representative Fett for opening remarks on House Study Bill 726.
Thank you, Mr. Chair. House Study Bill 726 is a bill that makes focused updates to Iowa's emergency measures by the governor of the state and public health laws. First, it restores proper legislative oversight by shortening disaster proclamations to 15 days and requiring legislative approval for any extension. It defines a disaster proclamation cannot violate constitutional rights, shut down businesses, alter elections, or restrict lawful medical practice. It also cannot block in-person religious or family visitation or allow licensing boards to limit prescribing in ways that undermine professional judgment. The bill prohibits the governor from imposing emergency measures that unduly interfere with religious institutions or individual religious practices. It modernizes public health authority by allowing HHS to only recommend, not mandate, tests, vaccines, or treatment, giving individuals full decision-making authority. Isolation remains available but limited to infected individuals and cannot extend the disease's usual incubation period. It replaces outdated recognized denomination language and with sincerely held religious belief and ensures the exemption remains valid during emergencies. Mr. Chair, there's an amendment.
There's an amendment. The chair recognizes Representative Fett for opening remarks on Amendment 2767.
Thank you, Mr. Chair. The amendment requires that when a state emergency is issued solely because of the federal government requires it to trigger federal action or grant a federal waiver, the proclamation must be written, signed by the governor, and filed publicly. Such proclamations are not subject to the timing and the amendment limits that are listed in the bill. If the proclamation constitutes a public disaster, it must also state so and otherwise comply with the bill. Those are my opening remarks.
Is there discussion on the amendment? The chair recognizes Representative Wilburn for remarks on Amendment 2767.
I do support the amendment. I believe it does help alleviate some logistical issues with FEMA requests that were brought up at the subcommittee.
Thank you. Any further discussion on the amendment? Seeing none, Representative Fett moves Amendment 2767 short form. All those in favor signify by saying aye. All those opposed say no. The ayes appear to have it. The ayes, you have it. The amendment is adopted. We are now back on House Study Bill 726 as amended. Is there further discussion? Chair recognizes Representative Wilburn.
I oppose this. I think it's too restrictive for both emergency situations as well as public health emergencies. Shrinking the time frame for an extension or repeal from 30 days to 15 is too short, I believe. In some cases, may not be able to get informed factual assessment of conditions or circumstances. I would support a required in-person legislative update with the Legislative Council, especially in out of session. And I say this as a former mayor and city council member that had to deal with local disaster, tornado, flood, that, the executive branch, whether it's governor or mayor, needs to have some flexibility to manage local circumstances that come up and can't be unforeseen. So I just think it's important to be able to retain that.
Thank you. Is there any further discussion? Seeing none, chair recognizes Representative Fett for closing remarks on House Study Bill 726 as amended.
Thank you, Mr. Chair. House Study Bill 726 is a bill that strengthens constitutional liberties, preserves essential public health tools, and clarifies the proper roles of the legislative and executive branches. I move the bill.
Representative Fett moves House Study Bill 726 as amended. The clerk will call the roll.
Representative Holt,
Aye.
Representative Lawler, Representative Wilburn,
No?
Representative Bagneski, Representative Dunwell, Representative Fett, Representative Gustav, Representative Nordman, Representative Ramirez, Representative Shipley, Representative Srinivas, Representative Stone, Representative M. Thompson, Representative C. Thompson, Representative Watkins, Representative Wessel Kershell, Representative Wheeler, Representative Wickendall, Representative Williams, Representative Wills. 14-6.
With a vote of 14-6, House Study Bill 726 is amended. We'll move to the floor as a committee bill. The chair recognizes Representative M. Thompson for opening remarks on House File 2554. Excuse me, C. Thompson for opening remarks on House File 2554.
Thank you, Mr. Chairman. House File 2554 closes a back door that's possible to use in contractual and other mechanisms for trying to sneak around our protections under the Constitution, both Iowa and federal, for civil rights and the Bill of Rights generally. This is putting into code what is already case law in many states for choice of law doctrine that you can't use the mechanism of a contract, for example, to make the Constitution not apply. So that concludes my opening remarks.
Is there discussion? Chair recognizes Representative Srinivas.
I agree with the premise of this. I do worry that it might be code clutter, but otherwise do agree with what this is saying. So I would urge a yes vote.
Is there any further discussion? Seeing none, the chair recognizes Representative Thompson for closing remarks on House File 2554.
I'd like to move the bill, please.
Representative Thompson moves the bill. Clerk will call the roll.
Representative Holt,
Aye.
Representative Lawler, Representative Wilburn,
Aye.
Representative Bagneski, Representative Dunwell, Representative Fett, Representative Gustoff, Representative Nordman, Representative Ramirez, Representative Shipley, Representative Srinivas, Representative Stone, Representative M. Thompson, Representative C. Thompson, Representative Watkins, Representative Wessel Kershell, Representative Wheeler, Representative Wickendall, Representative Williams, Representative Will. Unanimous.
With a unanimous vote, House File 2554 will move to the floor as a committee bill. The chair recognizes Representative C. Thompson for opening remarks on House Study Bill 750.
Thank you, Mr. Chairman. House Study Bill 750 is a similar proposed statute to close a backdoor in an emerging area of real estate. There's a relatively new to Iowa theory that you can create an LLC, then put into the LLC limited ownership units that would permit residential status in the real estate in question. This imposes on such arrangements the fair housing rules that are statutes that we would ordinarily apply to residential real estate in the state of Iowa. I note that at the subcommittee, some people raised questions about the lack of definitions in a couple of the words in the statute or the bill. And I agree that those probably need to be revised, and that's something we'll commit to cleaning up once this reaches, or before this reaches the floor. That concludes my opening remarks.
Thank you. Is there discussion? Chair recognizes Representative Wickendall.
Thank you, Mr. Chair. Yes, there were indeed questions at the subcommittee, including what and and does this apply to me? I think this applies to me, but we're not sure. In general, I kind of think that this is a bill that just should be shelved for this 92nd General Assembly, and there's more care and time needed to work on that. So I'll be voting no on this today.
Is there any further discussion? Seeing none, the chair recognizes Representative Thompson for closing remarks on House File 2554.
I thank the members of the subcommittee and Representative
Excuse me,
Wickendall.
House Study Bill 750 is what we're on right now, right? I apologize. Closing remarks on House Study Bill 750.
Sorry, I missed that altogether.
I said the wrong bill. So I'm recognizing you for closing remarks on House Study Bill 750. Sorry.
Anyway, I appreciate the comments on the bill, but I think it's always probably a good time to make sure that fair housing laws are enforced in the state, and that this is an important emerging area of residential dwelling. So I think it's probably a good time to make sure that happens. So accordingly, I move the bill. Thank you.
Representative Thompson moves House Study Bill 750. Clerk will call the roll.
Representative Holt,
Aye.
Representative Lawler, Representative Wilburn,
Aye.
Representative Bagneski, Representative Dunwell, Representative Fett, Representative Gustoff, Representative Nordman, Representative Ramirez, Representative Shipley, Representative Srinivas, Representative Stone, Representative M. Thompson, Representative C. Thompson, Representative Watkins, Representative Wessel Kershell, Representative Wheeler, Representative Wickendall, Representative Williams, Representative Wills. 19-1.
With a vote of 19-1, House Study Bill 750 will move to the floor as a committee bill. Chair recognizes Representative Lawler for opening remarks on House File 2555.
Thank you, Mr. Chair. House File 2555 relates to license plate readers. License plate readers are an incredible tool for law enforcement. Even small numbers of them can dramatically increase the chance of solving crimes ranging from property crime to human trafficking to Amber Alerts even to a murder that involved a vehicle found with these things near where I live in a rural part of a county. Just as we did with the DNA bill, if we're serious about solving crime and taking on crime, we need to give law enforcement the tools to do that. So this bill seeks to balance Fourth Amendment concerns, privacy concerns, with the need for these tools. Those are my opening comments.
Is there discussion? Chair recognizes Representative Bagneski.
Thank you, Mr. Chair. I think there have been 3 different bills filed on this topic this week. So I think we've all tried to become experts as quickly as we can. I don't know that we are experts, but I think this is a good synthesis of what we've seen. I think it's a good balance between public safety and individual rights. So I urge everybody to support this good compromise.
Thank you. Is there any further discussion? Chair recognizes Representative Thompson.
Thank you, Mr. Chairman. I support this bill. I think it's a good start on getting a good regulatory scheme in the state and would put us in the lead among other states.
Thank you. Is there any further discussion? Seeing none, the chair recognizes Representative Lawler for closing remarks on House File 2555. Representative Lawler moves House File 2555. The clerk will call the roll.
Representative Holt,
Aye.
Representative Lawler, Representative Wilburn,
Aye.
Representative Bagneski, Representative Dunwell, Representative Fett, Representative Gustoff, Representative Nordman, Representative Ramirez, Representative Shipley, Representative Srinivas, Representative Stone, Representative M. Thompson, Representative C. Thompson, Representative Watkins, Representative Wessel Kershell, Representative Wheeler, Representative Wickendall, Representative Williams, Representative Wills. Unanimous.
With a unanimous vote, House File 2555 will move to the floor as a committee bill. If there are no objections at this time, I will turn the chair over to Representative Lawler.
Chair recognizes Representative Holt for opening comments on House File 668.
Thank you. House File 668 creates a presumption that the person reasonably believed the use of force was necessary for defense of self, another person, or property from what the person reasonably believed to be an imminent threat from another person. Law enforcement will only arrest if there is a probable cause to believe that the force that was used was unlawful. It further provides that when a justified use of force immunity has been raised by a person at a pretrial immunity hearing, the burden of proof by clear and convincing evidence is on the state. There are still a number of ongoing discussions with county attorneys regarding a number of concerns on this legislation. So we will see where it goes from here. But I'm extremely concerned about this particular issue because I think there have been some lives ruined because this wasn't looked at on the front end. So that is what is behind the legislation. That concludes my opening remarks.
Thank you. Is there further discussion? Chair recognizes Representative Wessel Kershell.
Thank you, Mr. Chair. I was a little surprised to see this on the agenda today because it was my understanding from subcommittee that it needs a lot of work. It's a pretty big bill, and I would like to see that work done before actually voting on it. In my estimation, it will make accountability harder in questionable shootings or violent encounters, and therefore today I am a no vote. Thank you.
Thank you. Seeing no further discussion, the chair recognizes Representative Holt for closing remarks.
Thank you, Representative Russell Kershell. There were a lot of concerns raised, and so I'm continuing to discuss those concerns with county attorneys and others. But I am aware of situations in which there was a justified use of force, but the person was still arrested and had their lives ruined. And so that is why we're going to see what we can do to address this. Having said that, I move House File 668.
Representative Holt moves House File 668. The clerk will call the roll.
Representative Holt,
Aye.
Representative Lawler, Representative Wilburn,
No.
Representative Bagneski, Representative Dunwell, Representative Fett, Representative Gustoff, Representative Nordman, Representative Ramirez, Representative Shipley, Representative Srinivas, Representative Stone, Representative M. Thompson, Representative C. Thompson, Representative Watkins, Representative Wessel Kershell, Representative Wheeler, Representative Wickendall, Representative Williams, Representative Wills. 15-5.
Vote is 15 ayes and 5 nays, and the bill is approved. House File 668 moves to the House floor as a committee bill. The chair recognizes Representative Holt for opening comments on House Study Bill 722.
Thank you, Mr. Chair. This legislation makes significant changes to the magistrate system here in Iowa. It is an initiative of the judicial branch. The existing system for magistrates has been in place for over 40 years. The current system mandates a specific number of magistrates, and with the massive changes that have been made in technology in recent times, with warrants now being done remotely, changing to a more efficient cost-saving system seems to make sense. The legislation shifts magistrate appointments from individual counties to judicial election districts. It removes the statutory number of magistrates per county, authorizing the Supreme Court to develop a formula based on workload to allocate magistrates among judicial election districts. It changes the magistrate appointing commission membership and eliminates the requirement for public notices of magistrate vacancies in county newspapers. It establishes the role of senior magistrates for retired magistrates, meeting age and service requirements. It sets rules for senior magistrate compensation, including salary, reimbursement, and medical insurance, and provides for the removal or voluntary relinquishment. It raises judicial officer salaries by 5% in June 2027 and sets magistrate compensation at 40% of district associate judge salaries. And it appropriates funds for these increases and enacts most of these changes on November 1st, 2026. This concludes my opening remarks.
Thank you. Is there discussion? Representative Wilburn.
Thanks, Mr. Chair. I rise in support of the rise in support. I support. Sorry. I'm sitting in support of this. Yeah, I mean, there needs to be some updates. Even those who've expressed concerns about this, there should be a planful about going to do this. I'm eager to hear what some of those alternatives might be, but do support, in particular, increasing that the pay, and we'll move forward with this.
Thank you. Seeing no further discussion, the chair recognizes Representative Holt for closing remarks.
Thank you. And to Representative Wilburn's point, there's a great deal of concern from legislation from our magistrates and from some others. And I'm going to continue to gather information, listening to all of those concerns. I welcome input from everyone as we work to make our judicial system as responsive and efficient as possible in the administration of justice. Again, I welcome suggestions from the Magistrate Association and from others on how we can make the system better and what changes they would recommend to this legislation. Mr. Chair, I move House Study Bill 722.
Representative Holt moves House Study Bill 722. The clerk will call the roll.
Representative Holt, Representative Lawler, Representative Wilburn,
Aye.
Representative Bagneski, Representative Dunwell, Representative Fett, Representative Gustoff, Representative Nordman, Representative Ramirez, Representative Shipley, Representative Srinivas, Representative Stone, Representative M. Thompson, Representative C. Thompson, Representative Watkins, Representative Wessel Kershell, Representative Wheeler, Representative Wickendall, Representative Williams, Representative Wills. 18-2.
Vote is 18 ayes and 2 nays, and the bill is approved. House Study Bill 722 moves to the House floor as a committee bill. The chair recognizes Representative Holt for opening comments on House Study Bill 616.
Thank you, Mr. Chair. This legislation is in response to a Supreme Court decision that changed what had been standard practice for decades regarding payment of court costs. The language seeks to return to the status quo for pecuniary damages. This language is by no means a done deal. I have been speaking with the ACLU on some concerns they have about how the language is written, so it will not be the final language, but I just did not have a chance before this committee to nail that completely down. So it will need to be refined before it comes to the floor, and I would welcome input from interested stakeholders. This will not be the final language, but this will be the vehicle with which we will hopefully get this fixed. This concludes my opening remarks.
Is there discussion? Representative Bagneski.
Thank you, Mr. Chair. I echo Representative Holt's statement. I think that there is still some work to be done on this, but I look forward to getting it to the floor. I urge everybody to support it.
Seeing no further discussion, chair recognizes Representative Holt for closing remarks. Representative Holt moves House Study Bill 616. Clerk will call the roll.
Representative Holt, Representative Lawler, Representative Wilburn,
Aye.
Representative Bagneski, Representative Dunwell, Representative Fett, Representative Gustoff, Representative Nordman, Representative Ramirez, Representative Shipley, Representative Srinivas, Representative Stone. Yes. Representative Stone, Representative M. Thompson, Representative C. Thompson, Representative Watkins, Representative Wessel Kershell, Representative Wheeler, Representative Wickendall, Representative Williams, Representative Wills. 19-1.
With a vote of 19-1, the bill is approved. House Study Bill 616 moves to the House floor as a committee bill. The chair recognizes Representative Holt for opening comments on House Study Bill 738.
Thank you. And some of you may be asking, what the heck? So I will explain this. I submitted this bill after speaking with some county supervisors who were advised by their county attorney that language in the code was so vague that it was uncertain whether the county supervisors could discipline and or terminate a rogue assessor or an assessor in violation of employment standards or engaging in unethical conduct. Clearly, assessors must be protected from retaliation related to assessments, but all of us have to answer to someone. And in the case of the assessor, it would seem to me that they should answer to the body that appointed them, but the language in code is very vague, and this is becoming a problem. So I would say, just like the last bill, this language is a work in progress. I've reached out to the Assessors Association. Hopefully they'll be getting back to me. But the whole point here is to make sure that assessors, like everybody else in government, can be held accountable for unacceptable conduct like lavish vacations or abusing taxpayers, this sort of thing. That's what we're trying to get at here. That concludes my opening remarks.
Is there discussion? Representative Wickendall.
Yes, thanks, Mr. Chair. I did serve on this subcommittee, and in general, I'm supportive of the bill. I do believe the phrase applicable employment standards might be a little too broad, but overall, I agree with the concept of the bill and will recommend a yes.
Thank you. Is there further discussion? Seeing none, chair recognizes Representative Holt for closing remarks.
And I'm certainly open to fixing that. Like I said, this is not a done deal. I'm just trying to make sure that people that are abusing the system are held accountable for the taxpayers. With that, I move House Study Bill 738.
Representative Holt moves House Study Bill 738. The clerk will call the roll.
Representative Holt, Representative Lawler, Representative Wilburn,
Aye.
Representative Bagneski, Representative Dunwell, Representative Fett, Representative Gustoff, Representative Nordman, Representative Ramirez, Representative Shipley, Representative Srinivas, Representative Stone, Representative M. Thompson, Representative C. Thompson, Representative Watkins, Representative Wessel-Kershell, Representative Wheeler, Representative Wickendall, Representative Williams, Representative Wills. Unanimous.
With unanimous vote, the bill is approved. House Study Bill 738 moves to the House floor as a committee bill. The chair turns the chair back to the committee chair.
Thank you. At this time, the chair recognizes Representative Wills for opening remarks on House File 2413. Excuse me, Representative Lawler for opening remarks on House File 2413. I was looking at the wrong name. Were you ready, Representative Wills? Did I wake you up?
Thought I was going to get a little break there. This bill, House File 2413. The purpose of this bill is to reestablish accountability for major rules created by bureaucrats and agencies that impose large costs on Iowans, whether it's in their personal lives or in their businesses. So the goal is to cut red tape, fight hidden taxes, fight inflation caused by bureaucrats. There's an amendment.
There's an amendment. The chair recognizes Representative Lawler for opening remarks on Amendment 2750.
The amendment creates exceptions to the major rule requirement for regular summer E15 waivers and for regular IPERS contribution changes. Those are my remarks on the amendment.
Is there discussion on the amendment? Seeing none, Representative Lawler, you're recognized for closing remarks on Amendment 2750.
No, I move it.
Representative Lawler moves Amendment 2750 short form. All those in favor signify by saying aye. All those opposed say no. The ayes appear to have it. The ayes do have it. The amendment is adopted. We're now back on House File 2413 as amended. Is there further discussion? Chair recognizes Representative Bagneski.
Thank you, Mr. Chair. I'm glad to see that we put forth an amendment for IPERS on this bill. My concern is, are there other programs, are there other expenditures that we're not thinking of that we didn't catch? In that vein, my remarks at the subcommittee were that I was concerned that we're restricting government's ability to respond to crises and natural disasters, whether it's avian flu or a terrorist attack or a natural disaster, an attack on the food supply, a farm mortgage crisis, God forbid. What are we doing to ourselves with this legislation? And if we thought through every potential avenue that we might have to deal with, and in fairness, I want to say that this bill does have provisions in there that the governor would have some powers to have a temporary decision that would be ratified by the legislature. My concern is, the bargaining power for that governor might be somewhat limited if any decision they make or any deal that they have with public or private actors could be overturned just a couple months later. So I think that there's still a lot left to be answered in this bill. I hope we continue to work on it if we go forward, but I would urge my caucus to oppose it.
Thank you. Is there any further discussion? Seeing none, the chair recognizes Representative Lawler for closing remarks on House File 2413 as amended.
I appreciate the comments from Representative Bagneski as he recognizes there is a provision in the bill that attempts to address that provides for coordination by the governor with the legislative council. I would also note that this bill has been passed by other states, including Florida 16 years ago, Wisconsin almost a decade ago. So they've handled crises like COVID already under this regime. That concludes my remarks.
Representative Lawler moves House File 2413 as amended. The clerk will call the roll.
Representative Holt,
Aye.
Representative Lawler, Representative Wilburn,
No.
Representative Bagneski, Representative Dunwell, Representative Fett, Representative Gustoff, Representative Nordman, Representative Ramirez, Representative Shipley, Representative Srinivas, Representative Stone, Representative M. Thompson, Representative C. Thompson, Representative Watkins, Representative Wessel Kershell, Representative Wheeler, Representative Wickendall, Representative Williams, Representative Wills. 14-6.
With a vote of 14-6, House File 2413 as amended will move to the floor as a committee bill. The chair recognizes Representative M. Thompson for opening remarks on House File 2144.
House File 2144 allows victims of human trafficking to petition for expungement of their criminal records for offenses committed while they were victims of human trafficking. The bill sets forth procedures for filling out those petitions. It also does not include serious felonies. That is not included in here. In other words, if the victim was compelled to shoplift, if the victim was compelled to do credit card fraud, something of that nature, she or he can appeal that crime. It should be mentioned that only a handful of other states have or have not passed this bill. We're in the distinct minority there, and other folks have done that. The two victims that I had, frankly, the honor to be with this summer, one was from Florida, one was from Wisconsin. The one from Florida had a much easier time getting back in the workforce, getting settled, getting her life back on track, slowly but surely. The one from Wisconsin had a much more difficult time. This bill sets forth a procedure to make sure they're taken care of. Thank you.
Is there discussion? Chair recognizes Representative Wilburn.
Oops. Yes, I recommend a yes on this so that folks that find themselves in these circumstances have an option. I do think it's important that we make sure that there is indigent defense because if someone were to try to do a petition on their own and end up making a mistake, could end up with a Class D felony for applying under a false pretext. So, but recommended yes.
Any further discussion? Seeing none, the chair recognizes Representative Thompson for closing remarks on House File 2144.
I move the bill.
Representative Thompson moves House File 2144. The clerk will call the roll.
Representative Holt,
Aye.
Representative Lawler, Representative Wilburn,
Aye.
Representative Bagneski, Representative Dunwell, Representative Fett, Representative Gustoff, Representative Nordman, Representative Ramirez, Representative Shipley, Representative Srinivas, Representative Stone, Representative M. Thompson, Representative C. Thompson, Representative Watkins, Representative Wessel Kershell, Representative Wheeler, Representative Wickendall, Representative Williams, Representative Wills. Unanimous.
With unanimous vote, House File 2144 will move to the floor as a committee bill. The chair recognizes Representative Gustoff for opening remarks on House Study Bill 570.
Thank you, Mr. Chairman. This is a bill that comes to us from the Attorney General. It's kind of a long bill, but I'll distill it down to this. It makes several victim protection updates, especially on sexual abuse victims. Victim counselors, it clarifies and strengthens the victim counselor confidentiality and privilege. It adds a good faith immunity exemption for disclosures made under statute. It modifies protective orders for victims of particular sexual crimes that can be extended, including that can last for any length of time up to a victim's lifetime. Sex offender registration tightens the deadlines and adds in-person reporting requirements. It extends retention of sexual abuse victim evidence kits for 20 years or for the lifetime of a minor victim. And adds notice provisions for before those are disposed of. Competency and civil commitment hearings have some revision here to add clearer timelines and procedures for independent evaluations when restoration is unlikely. We do reclassify some victim compensation program reimbursement in here. And then there's some updates to sexual assault examiner training oversight to align with Department of Justice approved guidelines. Those are my opening comments.
Brett, stop. Is there an amendment?
There's not an amendment. There is an amendment? Yeah. Oh, is this one strike section 15? Yes. Sorry.
So let me
Yes.
recognize you for amendment 2750.
2630.
Excuse me. Yeah,
Yes.
amendment 2630.
Yes, I'm sorry. It strikes section 6, amendment 2630 strikes section 15 unnecessary reference to the Victim Crime Compensation Program.
Thank you. Is there discussion on amendment 2630? Chair recognizes Representative Ramirez.
Thank you, Mr. Chair. I'm in support of this amendment.
Thank you. Is there any further discussion? Seeing none, Representative Gustav moves amendment 2630, a short form. All those in favor signify by saying aye. All those opposed say no. The ayes appear to have it. The ayes, you have it. Amendment 2630 is adopted. We're now back on House Study Bill 570 as amended. Is there further discussion? Chair recognizes Representative Ramirez.
Thank you, Mr. Chair. I'll be honest, there's a few elements of this bill that's really, really great. I think particularly Division 4 outlines a lot of the elements that Representative Gustav described. It keeping the sexual abuse kits for longer, notifying the victims of disposal of kits. All of these are really great things. I wish this was a standalone bill. Unfortunately, what we saw at our subcommittee was countless victim service providers flagging that this bill will actually, as it stands, will actually harm victims. I had the Iowa Coalition of Domestic Violence reached out to me. They represent 25 victim service providers that work directly with victims of sexual violence and domestic violence. They are registered against this bill and describe that the confidentiality component of the victim counselors Division 1 section would require victim counselors to disclose client information without victim consent. So I wanted to share a few of their thoughts as well as my own. For victims of sexual assault and domestic violence, human trafficking, the decision to seek help is very difficult and it comes at great personal risk. As you can imagine, as a service provider, all of the calls that you're yielding are dealing with very, very high risk situations. That is the very nature of their job. So having the provision to say that now you should and you have full ability to make these calls to law enforcement based off of what your clients then told you, it doesn't give the assurance that an advocate needs to be able to safely help a victim. This confidentiality is what allows survivors to be honest about their circumstances and then be able to find a path forward. We heard from victim service providers that although they recognize the intent is to help victims, that's not actually going to be the outcome of what happens. From the Iowa Coalition of Domestic Violence, I want to quote them. Quote, "We recommend deleting provisions in House Study Bill 57, page 2, lines 23 through 25, page 2, lines 24 through 36, page 3, lines 1 through 6, altogether and simply amending a different code section, i.e. any new state exceptions to victim confidentiality without client consent are unnecessary and harmful. Without confidentiality, many victims will avoid seeking help or limit the information they disclose, which makes it harder to help them. Training is a more effective and appropriate way to prepare victim counselors for navigating escalating threats to safety. A redundant and less precise provision layered on top does not strengthen protections. It introduces conflict, invites inconsistency, and creates conditions where efforts to help could cause harm instead. Finally, the information for which disclosure is sought to be compelled is the victim's information. The victim and the victim alone should be allowed to decide whether that information should be disclosed and to whom it should be disclosed. They go on to share more about their concerns. So I do think that, you know, if we proceed forward with this, this would need quite a lot of work, given that I think the intent of the bill was to help victim service providers and victims alike. But as it stands, it would do the exact opposite and put victim counselors in a uncomfortable position where they would then be having to elevate their calls to law enforcement or feel the need to. It would create that pressure, and then victims would be harmed. There are some other concerns that were flagged in other divisions, specifically around mental competency division. And then also I had some nurses, I think, reached out to some of us members on the subcommittee that were concerned about Division 7. They shared some concerns around the change of the guidelines and felt that it would weaken standards and make them duplicative. Long story short, I would love for us to continue working on it if we proceed to move this bill forward, but I would recommend a no at this time.
Thank you.
Thank you.
Is there any further discussion? Seeing none, the chair recognizes Representative Gustav for closing remarks on House Study Bill 570 as amended.
Thank you, and I appreciate those comments. I appreciated the input from the subcommittee and following from different groups. So it's not uniformly opposed. This language, the requested change here came from, among others, we asked the Attorney General's office about that. Where did this come from? What was the initiative? Family Crisis Center in Sioux Center, Family Resources in Davenport, Crisis Intervention Services in Mason City, dozens of victim advocates, counselors around the state that they had roundtable discussions with. So it's not uniformly opposed by those in the field, and I dug in, did some research on my own as to what other professions. The disclosure here is required upon imminent risk of serious physical injury or death to the victim or another person. That makes it consistent in line with what lawyers deal with under Rule 32 of our professional. Representative Thompson, Representative lawyers, we have the ethical obligations, as is Representative Bagnuski. Representative Srinivas is a doctor, and under Iowa Code Chapter Section 228.6, there are similar disclosure requirements if there's risk of imminent threat or death. And healthcare providers deal with this under Iowa Code Chapter or Section 147.111. So I don't see this as out of the norm. It's consistent with, and those are just three professions I looked up, but it's consistent with other professions out there. It's not requiring broad disclosure of all kinds of discussions. It's only in those limited circumstances that there's risk of serious physical injury or death to the victim or another person. I think it's a good bill. It's a great tool. There's some work that needs to be done on it. We'll continue working on it. But with that, I move the bill.
Thank you. And Lisa and Laura, I would like to talk to you along with Representative Gustav between now and when it comes to the floor. Okay. Thank you. Okay. Representative Gustav moves House Study Bill 570 as amended. The clerk will call the roll.
Representative Holt.
Aye.
Representative Lawler. Representative Wilburn.
No.
Representative Bagneski. Representative Dunwell. Representative Fett. Representative Gustav. Representative Nordman. Representative Ramirez. Representative Shipley. Representative Srinivas. Representative Stone. Representative M. Thompson. Representative C. Thompson. Representative Watkins. Representative Wessel-Krishel. Representative Wheeler. Representative Wickendall. Representative Williams. Representative Wills. Oh. 2, 3, 4, 5, 6, 7, 8, 16. 16-4.
Thank you. With a vote of 16-4, House Study Bill 570 as amended will move to the floor as a committee bill. Chair recognizes Representative Gustav for opening remarks on House File 853.
Thank you, Mr. Chairman. This would be more appropriate on Groundhog's Day because we've seen this bill before. In fact, in the 90th General Assembly, we passed this through this committee and passed it through the House chamber 96-0, and it got stalled in the Senate. We passed it last year through the committee and didn't get taken up on the floor with the rush of things at the end. This bill would require a de novo review if somebody violates rules that are promulgated by the department after we pass a law, and their ALJ, their own internal judge, determines that yes, indeed, there was a violation of the rules, and it's appealed to a district court. This would require a de novo review of the law, which in my mind is the judiciary's obligation to look at the law and not just defer to what somebody in a department who's not elected nor a judicial officer of the court has determined what the law means. With that, those are my opening comments.
Is there discussion? Chair recognizes Representative Wilburn.
I'm going to break that Groundhog's Day and be a no. I did express concern before that there may be circumstances where the court doesn't necessarily have the expertise in a particular area, and it may create potentially some backlogs and some decisions. So I'll be a no.
Is there any further discussion? Seeing none, the chair recognizes Representative Gustav for closing remarks on House File 853.
Thank you, Mr. Chairman, and thank you, Representative Wilburn, for sitting in short notice on the subcommittee with that too. And I'm working with a couple of organizations about licensing issues in particular and being able to defer to their expertise on that. So that's a point well taken, and so there probably will be some sort of amendment to this on the floor. Thank you.
Representative Gustav moves House File 853. Clerk will call the roll.
Representative Holt,
Aye.
Representative Lawler, Representative Wilburn,
No.
Representative Bagneski, Representative Dunwell, Representative Fett, Representative Gustav, Representative Nordman, Representative Ramirez, Representative Shipley, Representative Srinivas, Representative Stone, Representative M. Thompson, Representative C. Thompson, Representative Watkins, Representative Wessel Kershell, Representative Wheeler, Representative Wickendall, Representative Williams, Representative Wills. 14-6.
Thank you. With a vote of 14 to 6, House File 853 will move to the floor as a committee bill. Chair recognizes Representative Fett for opening remarks on House File 2436.
Thank you, Mr. Chair. House File 2436 updates Iowa's divorce statute to limit what name changes can be granted directly in a decree. Under the bill, the person may only return to their birth name or the name they used immediately before marriage as part of the divorce. Mr. Chair, there's an amendment.
There's an amendment. The chair recognizes Representative Fett for opening remarks on Amendment 2654.
The amendment is just a corrective amendment that strikes clerk of court and replaces it with court. Those are my opening remarks.
Is there discussion on the amendment? Seeing none, Representative Fett moves Amendment 2654 short form. All those in favor signify by saying aye. All those opposed say no. The ayes appear to have it. The ayes do have it. The amendment is adopted. We're now back on House File 2436 as amended. Is there further discussion? Chair recognizes Representative Bagneski.
I don't know that either of us knew that this was an issue before the subcommittee, but it appears that it is. I think this is a common sense proposal to hopefully deal with it, and I urge everybody to support this measure.
Thank you. Any further discussion? Seeing none, Representative Fett, you're recognized for closing remarks on House File 2436 as amended. Representative Fett moves House File 2436 as amended. The clerk will call the roll.
Representative Holt,
Aye.
Representative Lawler, Representative Wilburn,
Aye.
Representative Bagneski, Representative Dunwell, Representative Fett, Representative Gustav, Representative Nordman, Representative Ramirez, Representative Shipley, Representative Srinivas, Representative Stone, Representative M. Thompson, Representative C. Thompson, Representative Watkins, Representative Wessel Kershell, Representative Wheeler, Representative Wickendall, Representative Williams, Representative Wills. Unanimous.
With a unanimous vote, House File 2436 will move to the floor as a committee bill. The chair recognizes Representative C. Thompson for opening remarks on House Study Bill 631.
Thank you, Mr. Chairman. This bill is to mandate that the state court administrator collect and publish certain information related to the performance of district judges, mostly information that already exists in the computer systems but is not readily available to the public. A number of questions have been raised about this, so this is not a finished product. Two of the big questions that we'll work on it, should this pass, would be making sure as much as possible that the public viewing these statistics understand that not every case is the same. In fact, there are wild disparities between the complex cases and simple cases, and the numbers don't always tell the story. The other, and I'm not sure whether it'll be in this bill or another bill that is pending before us, involves security for judges and members of the judicial branch. I view that as critically important, so we have to get that right. In any event, those concludes my opening remarks. Thank you.
Is there discussion on House Study Bill 631? No? Going once, going twice? Chair recognizes Representative Wilburn.
In all fairness to me, this was one I had to sit in on. 631, right? Yeah. Oh, thank you. Okay, thank you for the reminder. So I'm gonna be a no, recommend a no on this. I understand the importance for the judicial officer performance review. However, I think there needs to be a clear referral to the department as to what information should be reviewed. I'd hate to see us 1 year from now or 2 years from now see a report and folks still not have their questions. So if you have questions about what you'd like to see on performance review, it should be, the director should be given as to what that information is. Right now, we just don't know what it would be. So I'm a no because of that reason.
Thank you. Any further discussion? Seeing none, the chair recognizes Representative Thompson for closing remarks on House Study Bill 631.
Yes, I welcome those remarks and look forward to working on the bill further. I would like to move the bill at this time.
Representative Thompson moves House Study Bill 631. The clerk will call the roll.
Representative Holt,
Aye.
Representative Lawler, Representative Wilburn,
No.
Representative Bagneski, Representative Dunwell, Representative Fett, Representative Gustoff, Representative Nordman, Representative Ramirez, Representative Shipley, Representative Srinivas, Representative Stone, Representative M. Thompson, Representative C. Thompson, Representative Watkins, Representative Wessel Kershell, Representative Wheeler, Representative Wickendall, Representative Williams, Representative Wills. 14-6.
Thank you. With a vote of 14-6, House Study Bill 631 will move to the floor as a committee bill. The chair recognizes Representative Stone for opening remarks on House Study Bill 741.
Thank you, Mr. Chair. There is an amendment.
There is an amendment. The chair recognizes Representative Stone for opening remarks on Amendment 2747.
Thank you, Mr. Chair. Amendment 2747 is a strike after amendment relating to interviews conducted with a child subsequent to a report of child abuse. This concludes my opening comments on Amendment 2747.
Is there discussion on the amendment? Chair recognizes Representative Ramirez.
I support this amendment.
Thank you. Is there any further discussion on the amendment? Seeing none, Representative Stone moves Amendment 2747 short form. All those in favor signify by saying aye. All those opposed say no. The ayes appear to have it. The ayes do have it. The amendment is adopted. We're now back on House Study Bill 741 as amended. Is there discussion? Chair recognizes Representative Ramirez.
Thank you, Mr. Chair. I had a few concerns prior to the amendment, but I do believe that the amendment makes our code a little bit more specific, makes the process a little bit more specific for what happens when police need to get involved in a child abuse case. I would be interested in working with Representative Stone on fine tuning some of the language if there's interest there. I had heard that the law enforcement was concerned they don't want to become social workers, right? They have other jobs to do. So there's some language in there that I'd be interested in shifting just to make sure that that goal is being met. However, I'll be a yes at this time. Thank you.
Thank you. Thank you. Any further discussion? Seeing none, Representative Stone moves House Study Bill 741 as amended. The clerk will call the roll.
Representative Holt,
Aye.
Representative Lawler, Representative Wilburn,
Aye.
Representative Bagneski, Representative Dunwell, Representative Fett, Representative Gustoff, Representative Nordman, Representative Ramirez, Representative Shipley, Representative Srinivas, Representative Stone, Representative M. Thompson, Representative C. Thompson, Representative Watkins, Representative Wessel Kershell, Representative Wheeler, Representative Wickendall, Representative Williams, Representative Wills. Unanimous.
With a unanimous vote, House Study Bill 741 will move to the floor as a committee bill. At this time, the chair recognizes Representative Fett for opening remarks on House File 2574.
Thank you, Mr. Chair. House File 2574 is a bill that bars a court from deferring judgment or sentencing when the defendant was a public employee or a public official at the time of an offense involving the theft or misappropriation of public funds, and the amount taken from the public employer exceeds $10,000. Those are my opening remarks.
Is there discussion? Chair recognizes Representative Wilburn.
Thank you, Mr. Chair. I support this measure given some recent theft issues involving public employees. There's a higher degree of trust expected by and honesty by the public, whether you're elected or appointed, hired. The clear and convincing standard is higher than the preponderance of evidence, so that also would be a signal to the public that if you get elected, if you take these jobs, you've got to take this seriously or get training so that you know what you're doing. It's not a pure mandatory minimum. It just says no deferred or suspended a sentence, so there would be some jail time. but it also provides an opportunity for the judge to consider mitigating circumstances. I gave the example of if there was a public employee who was either misled or compelled or pressured by an elected or supervisor to commit some type of fraud or theft, that would be a type of mitigating circumstance. So I support.
Is there any further discussion? Seeing none, let me just point out Representative Wilson submitted this bill. I thought it was a good bill, and here we are. So I appreciate her doing that. Representative Fett moves House File 2574. Clerk will call the roll.
Representative Holt.
Aye.
Representative Lawler. Representative Wilburn.
Aye.
Representative Bagneski. Representative Dunwell. Representative Fett. Representative Gustoff. Representative Nordman. Representative Ramirez. Representative Shipley. Representative Srinivas. Representative Stone. Representative M. Thompson. Representative C. Thompson. Representative Watkins. Representative Wessel Kershell. Representative Wheeler. Representative Wickendall. Representative Williams. Representative Wills. Unanimous.
With unanimous vote, House File 2574 will move to the floor as a committee bill. A few housekeeping things. First of all, I don't think this place could operate without the Hartsel girls. The pizza is because of them, and so many of us have functioned because of them. So I just have to do a shout out to them because they're pretty amazing. I would also just say in an hour and 10 minutes, we did 19 bills. So we are the best committee. Thank you all for your cooperation. Thank you all. Hope you have a safe drive home. If there are no further business to come before the committee, seeing none, Representative Russell Kershell moves.